Imagine signing a lease for your dream home. A 3-bedroom house, plenty of space, a fresh start with your future spouse, only to wake up one day and realize your landlord has secretly moved in next door. Not down the street, not across town, literally sharing a wall with you, living in an attached apartment that he promised would stay empty. And here's the kicker. It's all happening in what was advertised to you as a single-family home. That is exactly what happened to one couple in Texas, and their story raises some serious questions about tenant rights, lease agreements, and what you can actually do when a landlord crosses a very important line. Let's set the scene here, because the details really matter in a case like this. A couple in Texas, we'll call them the tenants, were house hunting and found what seemed like the perfect rental. A 3-bedroom single-family home, plenty of room, the kind of place you can actually build a life in. They met with the landlord, they toured the property, and during that process, the landlord mentioned something that could have easily been a red flag but was smoothed over pretty quickly. There was an attached apartment connected to the house. He explained it away easily, said it used to be used for an elderly family member who no longer lived there. He assured them it was going to stay empty. No one would be living there. It would just be an unused space attached to the property. Now here is where things get interesting from a legal standpoint. The landlord actually put language in the lease, language stating he reserved the right to access that attached apartment at any time. For many renters, especially first-time renters, that kind of clause might not set off alarm bells immediately. It sounds almost reasonable on the surface. Of course, the landlord needs access to parts of the property, right? But what the tenants did not anticipate, what most reasonable people would not anticipate, is that access at any time would eventually mean living there permanently with my wife. Because that is exactly what happened. At some point after the lease was signed and the tenants had moved in and settled into their home, the landlord and his wife moved into that attached apartment. Not temporarily, not for a short visit, permanently. This became their primary residence. And remember, there are no separate utility meters for that apartment. There is no separate mailing address. The apartment is functionally part of the same property, drawing from the same utilities, existing under the same roof as the home these tenants are paying rent to live in privately. So now this couple is living in what was sold to them as a single-family home, and their landlord is essentially their roommate, without their consent and without any agreement that this arrangement would ever happen. Let's walk through exactly how this situation unfolded and why it creates such a significant legal problem. When the tenants signed their lease, they had a reasonable expectation. That expectation was shaped by two things. First, the advertisement. The home was listed and marketed as a single-family home. That language is not just a description. It carries legal and practical implications about how the property is zoned, how it functions, and critically, what kind of privacy the occupants can expect. A single-family home, by definition, is meant to house one family, not one family plus a landlord and his wife in an adjacent unit. Second, the landlord made an explicit verbal representation, possibly also reflected in the lease itself, that the attached apartment would remain unoccupied. That is a promise. And when a landlord makes a promise that influences a tenant's decision to sign a lease, breaking that promise has legal consequences. Now let's talk about that access clause, because this is the part the landlord will likely try to hide behind if this ever goes to court or mediation. Yes, the lease gave him the right to access the apartment, but there is a massive legal difference between the right to access a space and the right to occupy it as a permanent residence. Access rights typically refer to things like maintenance, inspection, or retrieval of property. They do not, and almost certainly cannot legally, be stretched to mean I can move in whenever I feel like it and make this my home. In Texas, landlord-tenant law is governed primarily by the Texas Property Code. Under that code, tenants have rights related to quiet enjoyment of their rental property. Quiet enjoyment is a legal concept that means you have the right to use your rented space peacefully, without interference from the landlord or anyone else the landlord allows onto the property. When a landlord moves in next door, sharing utilities, sharing a physical structure, potentially able to hear conversations through walls. That is a textbook disruption of quiet enjoyment. There is also the question of breach of contract. A lease is a contract. Both parties agree to specific terms, and when one party violates those terms, the other party has legal remedies. In this case, the landlord made representations, both verbally and potentially in writing, that the apartment would remain empty. He then violated that representation. That is a breach. The fact that the home was advertised as a single-family home may also be relevant here, because if the property is being used in a way that contradicts its advertised nature, that could support claims of misrepresentation or fraud in the inducement, meaning the tenants were misled into signing the lease under false pretenses. The tenants in this story specifically asked about two potential courses of action: sending a cease and desist letter or filing a lawsuit. Both are legitimate options, and they are not mutually exclusive. A cease and desist letter is often a smart first step because it formally documents the dispute, puts the landlord on notice that the tenants are aware of their rights, and gives the landlord an opportunity to remedy the situation before things escalate. In Texas, if the landlord does not respond appropriately to a written notice, it strengthens the tenant's position in any subsequent legal action. If the cease and desist is ignored, the tenants could pursue a lawsuit for breach of lease. In Texas, tenants can sue in small claims court, known as justice court, for amounts up to $10,000 without needing an attorney. They could potentially seek compensation for the diminished value of what they are renting, damages related to the disruption of quiet enjoyment, and possibly even early lease termination without penalty if the court finds the landlord's conduct constitutes a material breach of the agreement. There is also a broader issue here that is worth naming directly: shared utilities. If the landlord is living in an attached unit with no separate meter, he is potentially benefiting from utilities that the tenants are paying for. Or at the very least, the situation creates an entanglement that was never disclosed or agreed to. That is another layer of potential legal exposure for the landlord. Here's what every renter needs to take away from this story, because situations like this are more common than people realize. Landlords do not always act in good faith. Sometimes promises are made during the leasing process that quietly disappear once ink is on paper, and sometimes lease language that seems innocent, like an access clause, is actually designed to give a landlord far more latitude than any reasonable tenant would agree to if they fully understood its implications. Before you sign any lease, read every single clause. If something gives your landlord the right to access any part of the property, ask explicitly what that means in practice. Get clarifications in writing. If a landlord tells you verbally that something will or will not happen, ask for that to be reflected in the lease. Verbal promises are notoriously hard to enforce, but written lease terms carry significant legal weight. If you are already in a situation like this one, document everything. Keep records of when the landlord moved in, any communications about the arrangement, your original lease agreement, and any advertisements for the property. Texas law requires certain notices to be in writing, so start creating that paper trail immediately. Send communications via email or certified mail so you have proof of delivery and timing. And if you believe your rights are being violated, do not wait. Consult with a tenant's rights attorney. Many offer free consultations, or reach out to a local legal aid organization. In Texas, organizations like Lone Star Legal Aid exist specifically to help tenants navigate situations like this one. You have rights, and those rights are worth fighting for. If this happened to you, if your landlord has moved into your property without your consent, violated the terms of your lease, or disrupted your right to quiet enjoyment, know that you are not without options. Document the situation, understand your rights under your state's tenant protection laws, and take action before the situation gets any worse. Stories like this one are a reminder that the lease you sign is one of the most important legal documents in your daily life, and understanding it fully is not optional. It is essential. If you found this breakdown helpful, subscribe to this channel. We cover real legal situations that real people face every day, breaking down what the law says and what you can actually do about it. Hit that subscribe button so you never miss a case that might just apply to your own life.